Good evening, friends. Welcome to our startup talk show. Today we have the topic annual compliances for private limited companies. Today our chief guest or speaker is Ms. Sruti Gupta. She is company secretary, BA and LLB. She has 5 years of experience of mentoring startup. She is doing this work from last, I can say 10 years of she has the experience for this. So let's have a big round of applause for her.
Thank you. Thank you so much, sir.
So over to Ms. Sruti Gupta.
Thank you. Thank you so much, sir.
Yeah, ma'am, please you may share your screen.
Sure. So it's disabled.
Admin, can you please check?
Please allow me.
Please check.
Yeah. Share. All right, friends. So the topic for today is annual compliances with private limited companies. So to start with, as we will be discussing about private limited companies, what is a private limited company? So, a private limited company, as described under Section 268 of the Companies Act, is a company which restricts the right of a shares to transfer. It has a limited number of members of 200 and should have minimum of 2 directors to it. Also, it prohibits any invitation to the public to subscribe for its shares and securities, unlike any other public listed companies. So, to come down to the crux of a private limited company in a very simple layman terms, a private limited company is something which is a association which has a limit of 200 members. I should say shareholders. It restricts the rights of its members to transfer it to any third person. Also, it prohibits any invitation to the public to subscribe for its shares. Now, to come back to, we will be starting its compliances since the day of its incorporation. So once a private limited company is incorporated, you have to hold a board meeting. Board meeting is held among the directors of the company, and that the first board meeting has to be held within 30 days of its incorporation. So if a company is incorporated, say at 31st of August, it has to hold its board meeting till 29th of September. Now, how many board meetings are to be held in a year? There are 4 board meetings, not having a gap of more than 120 days in between them. So, for one board meeting in each quarter is mandatory for any private limited company. Also, once you hold a board meeting, there has to be a notice given. How will the directors know there is a board meeting? So there can be 2, there can be several directors. So the manager or any person responsible for the compliances or for the official work of the company has to issue a notice of clear 7 days to all the directors of the company to for inviting them with the prescribed agenda to hold a board meeting. The quorum of the board meeting should be 1/3 of its total strength, or either 2 directors, which is mandatory, without which any decision made in the board meeting would be void. Now we have given the notice, we have invited a board meeting, we have invited the board of directors. What to be discussed in the first board meeting? The first board meeting is generally, there are few basic 10 principles which are to be discussed in the first board meeting, which are: first, the certificate of incorporation of the company. We tell the board of directors, see, we have received a certificate of incorporation of the company. This is the MOA and the AOA of the company, which entails what is the object of the company, where its registered office is, what principles the company would work. We also tell the directors that, see, this is the registered office of the company, and this is the place where future communications of the company to be made. Then we come back to the appointment of the first board of directors. We take note of it that these two people or three people, or say more of that, are the first directors of the company. And those directors need to share their disclosure of interest in the other companies. If any of the director is a director in any third company, it has to disclose in front of other directors his interest in any third company. We come back to fixing a financial year of a company. We fix a financial year. See, we will be discussing a financial statement from 1st of April till 31st of March. This has to be entailed in the first board meeting. Then we consider appointing first auditors of the company to account for the financial statements. We also discuss the preliminary expenses which are to be taken consideration, to be taken note of like how much of expenditure has been done on incorporating the company and various other preliminary expenses of the company. We also decide the who will be the authorized person to sign the register and the register of members and the minutes book of the company, and where it is to be kept. We also decide the letterhead of the company, in details of which we'll be discussing in the next slide. So, as discussed, a director under section 184 has to disclose its interest in any third company, and that disclosure has to be made either in the first board meeting of the company, in the first board meeting of each financial year, and the first board meeting held just after its interest arises. So this disclosure is mandatory. Any interest in any third company of the director has to be disclosed to the board of directors and to the company. Then appointment of the auditors of the company. The first auditor of the company is appointed till the first annual general meeting to be held, and thereafter annual general meeting से हम उसको हर साल ratify करते हैं for the period of 5 years. Then when we appoint a director, we request the director to show him or her his qualifications, whether he or she is qualified to be acted as a auditor of the company, because there are certain rules and regulations and restrictions on their taking auditorships of the company. So the auditor has to disclose his or her qualification to the board. Then the auditor's appointment, maintaining of statutory registers and the register of members, minutes book of the company, the register of minutes book, other respective registers such as register of members, register of debenture holders, or other security holders, say preference shareholders, register of directors, their interest, the register of their director shareholding, register of transfer, register of charges, are to be kept at the registered office of the company, not anywhere else. And each register has to be updated within 30 days of the event arises. Say a shareholder transfers its shares to any third person with the permission of the board, this event has to be incorporated in the register of members as well as the register of transfer within 30 days of the event arises, failing which there is a fine of minimum like of a maximum INR of 3 lakh rupees. As I told, we will be discussing this in the later part of the slide, the letterhead of the company. It's again one of the most important aspect of the company, which represent a company's authentication and via which various communications of the company goes. So the letter of the head of the company, as per section 12(3)(c) of the Companies Act 2013, has to have its name, its address of its registered office, corporate identification number, telephone number, fax number if any, also the website and the email address of the company. This is mandatory. Now we have been incorporated a company. We have done the introduction of the board of directors of the company, the first board of directors. What about the first shareholders or the subscribers of the company? The first subscribers of the company are should receive their shares, their number of prescribed shares within 60 days of the company's incorporation. Within 60 days, the board of directors has to allot the shareholders their part of shares. Now, how once the shares are allotted, also it is the company's responsibility to allot shares as well as to file the same with the ROC that the respective subscribers or the first shareholders of the company have paid their dues of the subscribed shares. That has to be mentioned to the ROC via form INC 20A, and this form has to be filed within 180 days of the company's incorporation. So now coming back to the half yearly compliances of the company, these were the very basic compliances which a company is required to do and must be done. Now the half yearly compliances includes the part of recently in 2019 the Ministry of Corporate Affairs has introduced a form which supports the MSME, micro and small industries, whereby if a company is dealing with any vendor and having any supply of goods or services from the MSME companies, they have to make their payments within 45 days. Failing which, the respective company has to disclose it to the MCA why it has not paid the respective amount to the MSME vendor. And that is done twice a year. For transactions done from April to September, 31st October is the last date to file the MSME forms with the Ministry of Corporate Affairs, and the transaction taken place from October to March. 1st April is the date, to April is the date, 30th April, sorry, is the date whereby you inform the ROC that why I have not paid, the respective company has not paid the MSME its required amount. So this is a beneficial step taken by the ROC and Ministry of Corporate Affairs towards the MSME support. Now we come back to DPT3. DPT3 is again it's an annual compliance, and whereby any company having any loan from, say, either central government, state government, or any funds taken by the central government, taken from the central government or the state government or any foreign government, any international bank, public financial institutions, a company, or any third company, or from the directors as well as relatives, family, friends, has to be disclosed by the company before or on 30th June every year. This is an information passed by the company to the ROC that the respective amount outstanding in its financial statements is not deposit. If it is deposit, it has another compliances to be made, and if it is not deposit, then DPT3 has to be filed. To note here, if there is no loan outstanding, then there is no need to file DPT3, as nil DPT3 is not filed with the ROC. Now, Director DIR 3 KYC is another form which is filed annually on or before 30th September in each financial year, which describes the KYC of the directors, whether there is any change of its address, change of its mobile number, email ID, or any basic information that has to be disclosed to the ROC before 30th September every financial year. Failing which, it has a fine of 5,000 rupees. Now, Ben 2. Ben 2 is a disclosure by the directors to the company and from the company to the Ministry of Corporate Affairs that respective directors of the company are not having or having any significant beneficial ownership in any third company, meaning holding more than 51% of shares either directly or through its relatives to any third company. This disclosure has to be made by the director to the company and further taken from the company to the Ministry of Corporate Affairs as per compliances. Now we come back to the annual general meeting, which is held in once in every year. The annual general meeting for the first financial year of a company can be held within 99 months of the financial year, end of the financial year. And for regular consecutive financial years, it can be held within 6 months. That is 30th September. Now, for similarly, just like board meetings, we have to give 7 days of clear notice. For AGM, we give 21 days of clear notice to the directors of the company, to the auditors of the company, to the company secretary, to the financial officers, to the executive officers, to the nominee director, to the debenture trustee, to the secretarial auditor of the company. So every important person has to be informed, every important stakeholder of the company has to be informed about its annual general meeting with a notice of 21 clear days. Now, how a company will hold its annual general meeting? So the quorum of annual general meeting has to be minimum 2 directors and 2 members personally present to represent the company. It has a few businesses, which includes the ordinary business, which is the declaration of the dividend, discussing the appointment of the auditor and its remunerations, discussing the financial statements as approved by the board of directors of the company. Now, the annual general meeting has to be held during the business hours, which is 9 a.m. to 6 p.m. A annual general meeting cannot be held before 9 a.m. or after 7 p.m. after 6 p.m. It cannot be held during the national holiday. It has to be held at a place where the registered office of the company is situated. It can be within the city, though not in the registered office premises. But there is an exemption given under the Companies Act 2013 for specifically private limited companies, whereby if the members of the company unanimously vote, then the meeting can be held anywhere in India. Compliances with the registrar of the companies after holding the annual general meeting. So AOC 4 has to be filed. AOC 4 represents the financial statement of the company, the balance sheet, profit and loss, cash flow statement, director's report, as well as the auditor's report of the financial statement. AOC 4 is filed within 30 days of the annual general meeting. Similarly, MGT 7 is also filed. MGT 7 is the annual return, whereby it lists the shareholders of the company, the number of share transfers held during the financial year for a company, the changes in the directorship of the directors of the company during the respective financial year. Filing of annual return can be done within 60 days. So AOC 4 is filed within 30 days and MGT 7 is filed within 60 days for a company. So these are the few basic compliances a private limited company has to follow for a financial year. Rest, as the event arises of, say, allotment of shares, share transfers, change of bank signatories, change of statutory auditors, say for any reason, executing different agreements with any third parties, the compliances follow respectively. So this is it. Thank you, Praveen sir.
We have one question from Ishan. He is asking, can you please share briefly what is the difference debenture shares and preference shares?
What is the
Difference between the preference shares and debenture shares.
preference shares and debenture shares? Okay. So debentureship is something where when you company, the debenture shares has the particular interest, and preference shareholders also have interest, but that is, there are certain differences between the compliances of both the shares. Debenture shareholders has to have the dividend during the year.
Another question is, suppose you are saying AGM should be held in India in same city. So question is, suppose one of directors is out of India from some other, overseas branch. So can still they have the, meeting?
Yes, sir, we can have a virtual, he can attend the AGM through virtually,
Actually
by
possible.
virtual means. Even the board meetings can be held these days after COVID
Okay.
virtually.
Virtually is possible.
Even if the directors or the members are not in the same city, they can
Okay.
attend it virtually.
Okay. Okay. Suppose a startup is new, matlab they are the idea based startup and they are planning to register their company. So there one question for Harshul is that how name reservation of company can be planned. What is the process of a new name reservation for the company?
Name reservation, all right. So see, first the company has to decide on a name. You have to propose two names to the ROC respectively. After searching the trademark, there should not be any existing trademark on the respective name, and there should not be any existing website, the domain name on the respective name. Also, there should not be any company, say within the same field of the company, going to be incorporated with the same name.
Okay. Okay. Means
Say,
suppose
if
one.
for an example, if a company is like, say, SMAV Technologies already exists,
Right.
one cannot get that similar name.
Okay. Okay. Means suppose someone is running the some website which is not registered, right? So this startup should not go for that name.
Website is not registered.
Yes.
See, if there is existing domain name and it is already taken away, then the ROC, the search report of ROC does not allow it.
Okay. Okay. I can recall one name like Naukri.com or which is their website, but they are registered as a Info Edge Private Limited. So means with same
So
name.
this is the brand name and your company name. Your brand name and your company name can be different.
Okay. Okay. That is possible.
I can have my brand as Cello, but the name of my company is something different.
Okay. That is possible. Okay. Ma'am, can you please share one question is from Neetu Kapoor. She is asking, what is the process of, closure of, private limited company?
The closure of private limited company is, there is a specific form. It depends upon how the company is being closed. Say for any reason, running after 4 5 years, or say the company has not just been incorporated and the director decides that they don't want to run it, or there is no further business or activities just after the incorporation. So if there is the reason that there is no business activity for after just after incorporation of the company, then the company can wind up, but it has to be done after 1 year of its incorporation only.
Okay. Another question from Jatin is that he is asking, what is the, this MOA or AOA? Can you please share one line brief on it?
Or MOA is the memorandum of association, and AOA is the articles of association. MOA has very basic important points of the company. The first point is its name. It contains the name of the company, the registered office of the company, and the object of the company. What is the main object for which the company is formed?
Okay.
Say for a textile industry, or for web designing, or for any other app designing. Also, the ancillary objects of the company, which supports the main object. See, if my object of the company is having an educational institution, then I would be having my website, I would be having my centers, I would be hiring teachers, and I would be engaging in all ancillary activities. So those objects are also to be defined with the MOA. The shares of the directors name of the companies, the first directors are mentioned, the shareholders are also mentioned in the AOA, the first subscribers of the company.
Let's have a last question from Neetu. She is asking, what is the process? Do private limited company has to release the annual, report for all
Yes,
stakeholders? For all stakeholders,
yes.
this is open for anyone, right?
It has to be, because the members of the company have to be given the annual financial status of the company.
This is open report actually. Anyone can access.
Yes.
So here,
No, it is not actually open. The directors of the company and the stakeholders has to show it to the shareholders. It has to make it open.
okay, okay,
You submit the financial statements at the annual general meeting before the members of the company.
okay, okay, right, right. Thank you, ma'am. Thank you for wonderful, experience you shared for our audience.
Thank you. Thank you so much, sir.
Again, I will, request my audience to big round of applause for your such a wonderful experience.
Thank you. Thank you so much, sir.